Hello everyone, welcome to Julius Academy. This is Sudipto. Today we are going to talk about a very important topic and very burning topic in recent days, that is hijab ban. February से ये hijab ban हर newspaper, हर news channel का headline बन चुका है. And I don't need to tell you what has happened, though I definitely touch upon the facts. But इस वीडियो में हम लोग जो रिसेंटली सुप्रीम कोर्ट ने एक जजमेंट दिया है उसके ऊपर एलैबोरेटिवली बात करेंगे एंड वी आर गोइंग टू लर्न कि फैक्ट्स ऑफ द केस, द लॉज बिहाइंड इट एंड हाउ बोथ द जजेस हैव गिवन देयर रीजनिंग इन रिलेशन टू प्रोहिबिशन ऑफ वेयरिंग द हिजाब. सो दिस वीडियो वुड बी क्वाइट इंफॉर्मेटिव, so please stay till the very end because we are going to dig deep about the wearing hijab. It should be banned or it should not. So let's start the video. Now, before starting the video, two very important things. If you haven't subscribed to this channel, can do subscribe to it and press the bell icon. And the second thing, you haven't joined the Telegram channel, do join it. Okay? And also, CLAT Capsule course is going to expire within 1 day or 2. आपके पास जब भी वीडियो आएगा, please do enroll. Check it out. The link is going below in the description. Let's start with the hijab ban case. Why we are talking about it? Supreme Court recently, in the month of October, has given the judgment in the name of Aishat Shifa versus State of Karnatake, जहाँ पर Supreme Court एक split verdict दिए हैं. Split verdict मतलब 1:1. Justice Heaven Gupta supported the prohibition, whereas Justice Sudhanshu Dhulia supported the wearing the hijab, and we are going to learn this particular topic in detail because it's a split verdict, 1:1. Refer to the larger bench. And we're going to learn more about that split verdict, what the Supreme Court has pronounced, and that's why we're talking about in this video. चलो इसके बारे में देखते हैं, बट पहले हम लोग थोड़ा लॉ जान लेते हैं हिजाब बैन के बारे में. उसके बाद फैक्ट्स जानेंगे, इश्यूज जानेंगे एंड दोनों आर्गुमेंट, दोनों जजेस के जो रीजनिंग है वो भी देखेंगे. फर्स्ट लेट्स टॉक अबाउट द लॉज. नाउ जब हिजाब की बात होती है तो राइट टू रिलीजन डेफिनेटली ये क्वेश्चन है, और राइट टू रिलीजन अगर हम लोग कभी भी क्वेश्चन में लाते हैं तो सबसे इंपॉर्टेंट आर्टिकल, आई डोंट नीड टू टेल यू ऑलरेडी नो इट, दैट इज आर्टिकल 25, इजंट इट? तो आर्टिकल 25 जो देते हैं हम लोगों को राइट टू रिलीजन, टू प्रोफेस, टू प्रैक्टिस, प्रोपोगेट, दैट इज द राइट टू रिलीजन. दैट कॉन्स्टिट्यूशनल गारंटीज दैट राइट थ्रू आर्टिकल 25(1). बट आर्टिकल 25(1) में और एक बहुत इंपॉर्टेंट चीज बताया गया, वो है कि this particular right is subject to certain other conditions like 1. Public health, morality, order, and other provisions of the part 3 of the Constitution. These are the various conditions this particular right is subject to. Let's look at another very important provision which is also going to get discussed here in this video, that is article 25(2). Now article 25(2) is specifically which gives basically the power to the state. The state can make any laws in relation to regulating or restricting the right to religion. मैं उतना elaborate नहीं कर रहा हूँ, आप स्क्रीन में देख सकते हो उसको. So this is what article 25(2)(a) talks about. Now another very other articles that have been mentioned in this particular case, article 19(1)(a), freedom of speech and expression, you already know it, and article 21, right to life and liberty. Now these are the articles that are discussed here in this particular case, and let's get into the facts of the case which you already know, but let me sum it up for you. Now इस केस में क्या हुआ था, एक उडुपी में एक कॉलेज है, ठीक है, प्री यूनिवर्सिटी कॉलेज, एंड इन दैट कॉलेज बेसिकली one guidelines have been issued by that particular authorities, university college authorities, that is prescribing the uniform code for all the students. Now after that prescription, what has happened is that many students belonging to Islamic faith, they were prohibited to enter into the college because they were wearing the hijab. They are not wearing the uniform code that has been prescribed by the particular college. Now here the problem lies is that there are a lot of political situation, unrest, and social media, a lot of things. You people know it. I'm not getting into all those things because that's not the part of this video, that the topic of the discussion here. But then that particular students, they approached the Karnatake High Court. Karnatake High Court said by upholding the prohibition while upholding the prohibition is that this hijab, the wearing the hijab, is not the essential religious practice of Islamic faith, and that's why the prohibition is absolutely justified. Fine, no problem. Now this case was in front of the Supreme Court after the Karnatake High Court, and Supreme Court in the 2-judge bench recently given the split verdict and referred to the larger bench that we are going to. और आज के इस वीडियो में हम लोग इसी स्प्लिट वर्डिक्ट के बारे में देखेंगे 1:1 जस्टिस सुधांशु धूलिया, जस्टिस हेमंत गुप्ता. सो लेट्स गेट इनटू द इश्यूज दैट इज देयर इन फ्रंट ऑफ अस. तो फर्स्ट इशू डेफिनेटली ये था कि इस पर्टिकुलर केस को लार्जर बेंच को रेफर किया जाए या नहीं एसेंशियल रिलीजियस प्रैक्टिस के मैटर में. फर्स्ट इशू. द सेकंड इज द प्रोहिबिशन दैट हैज बीन इशूड इन रिलेशन टू वेयरिंग द हिजाब दैट इज violative Article 25(1) or not, and also this wearing hijab is a fundamental right under Article 19(1)(a) or not in Article 21. So these are the three issues major that we are going to get into this particular video. So let's understand these three issues in relation to both this. It's a very interesting discussion. So let's start the court reasoning in this particular case. So first we are going to delve into the Justice Hemant Gupta's reasoning. Okay. And then we're going to get into Justice Sudhanshu Dhulia's reasoning. जैसे हेमंत गुप्ता के रीजनिंग हम लोग अगर देखेंगे, अगर मैं आपको एक लाइन में सम अप करूं, वो है कि कोई सेक्युलर प्लेस में रिलीजियस एंटिटी या रिलीजियस थिंग्स को एंटरटेन नहीं करना चाहिए. ठीक है, दैट व्हाट द जस्टिस हेमंत गुप्ता टॉक्ड अबाउट. नाउ जस्टिस हेमंत गुप्ता के बेसिकली ही सपोर्टेड द प्रोहिबिशन on wearing the hijab, and he has given certain basic reasoning to it why he has supported the prohibition. The first very reasoning that he has given, that prohibition on wearing hijab is not violative of Article 25(1), but rather it's in tune with Article 40. Let me elaborate. आपके लिए मैं elaborate करता हूँ. आर्टिकल 25(1) क्या करता है? आर्टिकल 25(1) एक इंडिविजुअल राइट देता है और इंडिविजुअल चॉइस देता है टू प्रोफेस प्रैक्टिस प्रोपोगेट आवर रिलीजन. बट आर्टिकल 25(1) में ये भी बोला जाता है दिस राइट इज सब्जेक्ट टू अदर फंडामेंटल राइट्स और द पार्ट 3 अदर प्रोविजंस ऑफ पार्ट 3 ऑफ द कॉन्स्टिट्यूशन. नाउ हियर इन दिस केस अगर देखा जाए जो गाइडलाइन इशू किया गया है वो बेसिकली सारे स्टूडेंट को एक इक्वल फुटिंग में डालने के लिए किया गया, क्योंकि यूनिफॉर्म कोड उन लोगों के लिए ड्रेस कोड बनाया गया है. एंड बाय दैट व्हाट हैज हैपेंड, इट इज बेसिकली एक इक्वलिटी कल्चर को अपलिफ्ट करने की बात की जा रही है. एंड बाय दैट दिस गाइडलाइंस टू प्रिस्क्राइब यूनिफॉर्म कोड, इट इज टू अपहोल्ड द राइट टू इक्वलिटी as per Justice Hemant Gupta rather than violative of Article 25(1). क्योंकि 25(1) is subject to Article 14 as per the article says. So यहाँ पर right to equality को अपहेल्ड किया जा रहा है, यूनिफॉर्मिटी को अपहेल्ड किया जा रहा है, नहीं कि 25 को वायलेट किया जा रहा है. फर्स्ट रीजनिंग जस्टिस हेमंत गुप्ता ने ये है. सेकेंड रीजनिंग हेमंत गुप्ता के यहाँ से आए कि ये जो स्कूल की बात हो रहा है गवर्नमेंट स्कूल, दिस इज स्टेट स्कूल, एंड दो it's a matter of freedom of choice. That freedom of choice of wearing hijab is coming from a religion, okay, that is regulated by the religion. But here comes the Article 25(a) और Article 25(a) basically ये बोलते हैं कि Article 25(a) के अंदर the state can regulate or restrict the religious activities, right? So here in this case the state-run school has regulated that religious activity, and Hemant Gupta said in relation to this, it's absolutely fine because state-run school, state-funded school, they have regulated it. It is their authority to do that. Third very important thing that Justice Hemant Gupta talked about is Article 19(1)(a). Another very important reasoning that is coming up from the another aspect जो हम लोग देखेंगे वो है कि wearing hijab is a part of freedom of speech and expression. Yeah, true. Article 19(1)(a) के अंदर बहुत इंपॉर्टेंट चीज है जो एक wearing hijab जो freedom choice है, जो individual freedom है वो आ रहा है. True. But Article 19(1)(a) is also subject to reasonable restriction, and that here state has or state school has just put a restriction in the working hours to wear that particular dress code. And the reason being because it is to uphold the right to equality, to uphold Article 14 that the Justice Hemant Gupta taught. So by mentioning this reasoning, the three valid reasoning, first is it's not valid about Article 25, it's a state-run school, and the third is it's not valid about Article 19(1)(a). Justice Hemant Gupta talked about that any secular place like educational institutions, here the religious entities should not be entertained, and that's why the prohibition is absolutely in alignment with the provision of the Constitution. Now let's look at the other picture. I hope you understood the one part, Justice Hemant Gupta. अब other side को देखते हैं. Other side है जैसे सुधांशु धुलिया. जैसे सुधांशु धुलिया के पूरे रीजनिंग को अगर मैं एक लाइन में सॉल्व करूं, वो है कि इंडिविजुअल चॉइस, जो वेयरिंग हिजाब है वो एक इंडिविजुअल का चॉइस है, एंड दैट शुड बी अपहोल्ड, that should be upheld in relation to secularism. Secularism के मैटर में इंडिविजुअल चॉइस होना चाहिए, एंड दो रिलीजियस बैकग्राउंड को हमेशा एंटरटेन करना चाहिए, क्योंकि ये एक रिलीजियस टॉलरेंस की बात कर रहे हैं हम लोग. यहाँ पर एक सेक्युलर कंट्री है, ये पर रिलीजियस टॉलरेंस दिखाया जाता है. From that aspect, Justice Sudhanshu Dhulia has opined in this particular judgment. Let's look at the reasoning what he has given. First reasoning he has given कि देखिए जो हिजाब इंसान पर हिजाब यूज करता है, पहनता है, तो that hijab is basically part of Article 25(1). True, and 25(1) क्या बताता है? 25(1) एक इंडिविजुअल राइट है. जैसे हेमंत गुप्ता जो बोले थे 25(1) के, जैसे सुधांशु धुलिया ने बोले कि नहीं ये 25(2) की मैटर नहीं है, ये 25(1) की मैटर है. यहाँ पर 25(1) जो इंडिविजुअल राइट है, इंडिविजुअल चॉइस है, उसके ऊपर ये जाता है राइट टू वेयर द हिजाब. एंड बाय दैट बेसिकली जो कर्नाटक हाई कोर्ट बोले थे कि ये एसेंशियल रिलीजियस प्रैक्टिस नहीं है इस्लामी फेथ के, वो बात ही नहीं है यहाँ पर. दिस इज नॉट ए केस ऑफ एसेंशियल रिलीजियस प्रैक्टिस, बट इट्स ए मैटर ऑफ ए चॉइस, इट्स ए मैटर ऑफ free will that they are practicing here and should be given the chance to wear the hijab. That's the first reasoning that Justice Sudhanshu Dhulia talked about. Second, he said it's a matter of theology. It's a matter of theology in the sense it's a matter of religious practices. What you are talking about, sir? Justice Sudhanshu Dhulia talked about referring the Ram Janmabhoomi case, Muhammad Siddiqui case. In that case, basically court said and court cautioned that the judiciary should not venture into the cases of theology. Rather than it's a matter, it should be left to the religious institutions to or religious practices जो करना चाहते हैं free will के ऊपर छोड़ देना चाहिए, ठीक है? Because the court is not well equipped to discuss or judge the matter of religious practices. And here referring that particular Ram Janmabhoomi case, Supreme Court said it's a matter of actually theology and should be left with the individual's will or individual's freedom. Leave it that. Third, Justice Sudhanshu Gupta, third reasoning, what he has given, the third reasoning he has given in relation to Vijay Emanuel case. Now, Vijay Emanuel case is the backbone of his reasoning. Many of the law students already know the Vijay Emanuel, but let me tell you the Vijay Emanuel case facts in 2-3 lines. It's a matter of 3 particular students from one government school. They belong to a certain faith of Jehovah's Witness. Now, उनके साथ प्रॉब्लम क्या था इस केस में? प्रॉब्लम ये था, these 3 students during the national anthem, whenever it's being played in the school, they used to stand up, but they didn't sing this national anthem, and that's why the matter approached the Supreme Court, and Supreme Court said they did not disrespect the national anthem because they used to stand up during the national anthem, but they didn't sing because they belong to certain faith and it's their individual choice. So that's why here in this particular case, right to wear a hijab is a matter of religious faith, a matter of article of faith, and it should be given the liberty to individual whether to wear the hijab or not to wear the hijab, rather than forcing them not to wear it or prohibiting them not to wear it. That's the third part they have given. The fourth reasoning that they have given, or the Justice basically Sudhanshu Dhulia given, that is the matter of privacy and dignity. Now, Sudhanshu Dhulia said that if any particular student who is prohibited to enter into classroom because of wearing the hijab, or he told not to wear hijab, after that he will be, or she is not going to be allowed to enter into the classroom because of wearing the hijab. In that case, it's a matter of her privacy. If she is not allowed, she is prohibited to wear the hijab. In that case, it's a matter of privacy, it's a matter of dignity, and that should be upheld first. And in the case of Aruna Roy, the Supreme Court said it's our constitutional morality and constitutional morality of that we should practice religious tolerance to different communities that we have, okay, different sects that we have, and that we should be proud of. From that viewpoint, Justice Sudhanshu Dhulia said it's a matter of privacy, it's a matter of dignity, it's a matter of individual choice, and should be upheld. And fourth thing that Justice Sudhanshu Dhulia talked about the preamble. Preamble talked about the liberty. Preamble talked about the fraternity, liberty of thought expression. And here the thought expression has been conducted by that Islamic students. And by that, how can they be prohibited to wear, or how can they be suffocated in relation to express their freedom to wear hijab? They cannot be, as per the Justice Sudhanshu Dhulia. So these are the two sides, and after this matter, in conclusion, I have to say this has been referred to larger branch because it's a split verdict. No conclusion has been drawn from that. What do you think? Whether the hijab should be banned, or the prohibition should be there, or prohibition should not be there wearing the hijab or not? Please mention below in the comment box, because we love to know. It's a matter of really burning topic, and for law students a very important topic, right? So आपके ओपिनियन भी आप शेयर कीजिए कमेंट बॉक्स में, और बताइए आपको कैसा लगा ये वीडियो. If you find it fruitful, give it a thumbs up, and don't forget to share this particular video to other fellow aspirants and other law students. Thank you. See you soon in the next video talking about another very important topic.